Welcome back. It is time for today's Talkback segment. Each day, we post a question on CourtTV's social media pages. We gather your comments and questions and respond on the show. New motions were filed today in the killing of Ahmaud Arbery. So we asked you, do you think the jury should be allowed to know that Arbery was on probation at the time of his death? Still with me, the Deputy Public Defender for Los Angeles County, Philip Dube. Our first comment comes from Vicky Tankis. Vicky says, no. The victim is not on trial, and the three men who murdered him most likely didn't know that either. And, I want to go back to our discussion from just a little bit ago, Philip, where you talked about that is not a requirement. Remind our viewers, it's not a requirement that they know everything about that victim's background in order for that to come in front of a jury.
Exactly. What it does is it brings in propensity evidence. In other words, you want to open the door to the victim's character. Obviously, there's no way to know who you're dealing with when you see people walking down the street. And for all we know, they're having a flashback, they're talking to themselves, and they just very abruptly become violent. Who knows? So if he has a history of assaultive behavior, violence, cold cocking people, that a jury needs to know that, because on the date of his death, it's very possible that that's how he behaved to them, and they had to respond in kind.
Yeah, and don't forget, we have that tape, so you can put it all within the context of that tape. Now, most of our viewers, Philip, did say no, the probation record should not be allowed, but one person did disagree. Karen Dugan said, it would depend on what he was on probation for. And I think, again, this goes back to what you said earlier. Had it been a violent felony, you see that as something that should be in front of this jury.
I absolutely agree. Not every offense for which you're on probation proves anything. I have clients who plead out, to selling popcorn on the street without a permit. Or for pushing a shopping cart because they're homeless illegally. Really? You want that to come into trial for what? It proves nothing. So this viewer is very astute, and I commend her. I wonder if she's in law school.
She might be. If not, she should be,
Okay.
Right?
Yes.
Here's a quick question that I want to get to, because there was some chatter about it on social media regarding a self-defense claim and how that changes the game a little bit in terms of what the jury is allowed to hear about the victim. There seems to be a movement a little bit towards the fact that more rather than less about the victim.
Well, I don't think that the history of his mental illness is relevant in this case. It's my understanding that I think he saw a counselor or a therapist once. It's not as if, he has a history of psychosis and that he's a violent psychopath. I mean, let's face it, Michael, every law and medical student probably took an occasional anti-anxiety or a mood stabilizer. Does that mean if we get into criminal trouble years later that all that evidence is going to come back to haunt us at a criminal trial? It should not. It demonizes mental illness, and it sends a message that every mentally ill person is violent and a psychopath. But in fact, most mentally ill people can manage their illness as long as they take their medication. In fact, a small percentage of the mentally ill is even dangerous or violent. Very small percentage.
No question. And I think one of the issues with that diagnosis, if you can even call it that, is that it was done by someone who wasn't really specialized in that area. I believe it was a nurse practitioner or someone along that line. All right, let's go to our next comment. Susie writes, all they need to know are the facts having to do with how he died that day and what led up to it. That's it. A judge recently ruled that information regarding the mental health of Ahmaud Arbery won't be admitted as evidence in the upcoming trial of his accused murderers. Again, that goes to what you just said. And in an ideal world, that would be the case in terms of what she said, in terms of only what happened in that sort of the four corners of the event. But that's not always the case, and appropriately so.
No, if you think about it, a video, especially as we have in this case, is a writing. Ultimately, under the law, it's viewed as a writing. Nobody gets to see what goes on outside the four corners or what led up to the creation of that writing. Do you see? So I think it is relevant to know what led up to it and what happened outside the eye of that camera. We don't know all the facts, and certainly these men on trial have their version of events, and we'll see. And it may require introduction of some character evidence about Ahmaud. Now, I understand it's a very sensitive issue, but listen, in the days of criminal trials, there is no room for political correctness. We cannot worry about being politically correct when people are looking at life.
Fair enough. Great comments. Truly appreciate it, Philip Dube. Always a pleasure to have you on the show. Truly appreciate it. You have a great evening. I'm Michael Ayala. It's been a pleasure being with you as well. Coming up next in Closing Arguments, Vinnie Politan takes a look at the biggest moment